In Singapore, animal cruelty carries penalties of up to $30,000 and 3 years in prison. Yet, the written law still categorizes these animals as property. Look at the exact language of Singapore's primary animal protection legislation, the Animals and Birds Act. The statute defines an animal purely by taxonomy as any beast, bird, fish, reptile, or insect. It catalogs what an animal is biologically, but contains no reference to a capacity to feel. This creates immediate logical friction. Section 42 of the Act prohibits causing unnecessary pain or suffering, but the law prohibits this suffering without statutorily acknowledging that the subject possesses a mind capable of experiencing it. This represents an implicit or de facto recognition of animal sentience. De facto refers to a state of affairs that exists in reality, even if it is not officially sanctioned by law. De jure recognition would require the formal written text of the statute to change. Because of this statutory gap, the legal system protects dogs and other animals as biological machines. With a comprehensive review of the Animals and Birds Act confirmed for 2026, resolving this contradiction is now a time-sensitive imperative. Operating under an outdated definition has consequences for the Animal and Veterinary Service, or AVS, the agency responsible for enforcing the law on the ground. The scale of the issue is significant. According to the SPCA's 2024 data, there were 2,190 known cruelty victims in Singapore. That averages out to 6 animals subjected to suffering or death every single day. When the law lacks an explicit definition of animal sentience, investigators hit a bottleneck. To build a prosecutable case, they are structurally forced to look for obvious, measurable physical trauma. This chart shows the volume of reported cruelty incidents contrasted with the actual prosecution rate. Historically, relying strictly on physical evidence has resulted in an exceptionally low conversion rate. Only 12.4% of reported incidents actually led to prosecution. Without explicit statutory footing, prosecutorial discretion remains inconsistent. The system handles broken bones effectively, but it struggles with modern, scientific understandings of psychological abuse. The tension between outdated laws and modern science collided in 2016 during the case of Public Prosecutor versus Ling Chung Yi Roy, known as the Hugo case. Hugo the Shetland sheepdog was kept in a cage measuring 61 by 46 by 53 centimeters. The defense argued a standard legal loophole. Upon rescue, Hugo exhibited zero measurable physical illness. By traditional metrics, he was healthy. This defense relied on the legal barrier of somatic pathology. Somatic pathology is the historical requirement in animal cruelty cases that physical bodily damage must be present to prove an animal has suffered.
The judge rejected that barrier, ruling that welfare is not exclusively dependent on physical health indicators. Instead, the court inferred mental suffering through behavioral ethology, the scientific study of animal behavior. This ruling officially decoupled legal welfare from somatic pathology. This was a continuation of a longer trend. The judicial foundation was laid earlier in the 2010 Butters case, which first advocated for recognizing psychological harm using behavioral evidence. This judicial evolution reached a new peak in 2025 with the Lin Peng Li Berry case, where the High Court took the step of explicitly characterizing animals as sentient creatures in its ruling. Yet, despite this evolution in the courtroom, the text of the Animals and Birds Act remains tied to its 1965 taxonomic language. While the Hugo case proved that judges can infer mental distress, forcing the courts to bridge the gap between a 1965 statute and 2025 science creates an unpredictable and fragile legal architecture. To resolve this gap between text and practice, we have to look at how other legal systems have engineered explicit sentience into their laws. We start with the constitutional and treaty-level model. The European Union achieved this with Article 13 of the treaty, which mandates that member states pay full regard to animal sentience in their policymaking. Germany integrated this concept directly into its constitution, amending Article 20A to fuse animal protection with the state's responsibility to protect the natural environment. Then there is the dedicated sentience legislation model, exemplified by the United Kingdom's Comprehensive Animal Welfare Sentience Act of 2022.
The core enforcement mechanism of the UK Act is procedural. It creates a mandatory requirement for government ministers to have due regard to the welfare of sentient vertebrates when making policy.
New Zealand pioneered this dedicated legislative approach, amending their Animal Welfare Act in 2015 to explicitly state that animals are sentient. The final architectural option is the Civil Code modification model, adopted by France in 2015. France reclassified animals out of the movable property category, legally defining them as living beings gifted with sentience. Spain followed with its 2021 to 2023 legislation, granting animals a dual characterization that specifically enhances their procedural standing in legal disputes. Whether through constitutional amendment, a dedicated act, or civil code reform, leading global jurisdictions are systematically removing implicit assumptions. This leaves Singapore's property-based act legally isolated. Current reform efforts in Singapore draw on veterinary science, judicial precedent, and public advocacy. The foundational policy document driving this is the 2025 SPCA Acres White Paper, which lays out 28 specific recommendations for explicitly protecting animal welfare. The government has responded. The Ministry of National Development confirmed a comprehensive review of the Animals and Birds Act, targeting public consultation for late 2026. There is active political engagement at the highest levels, with Minister of State Alvin Tan framing Singapore as a compassionate society for sentient beings. The confirmed 2026 government review is a high-stakes democratic mandate. It is the window needed to upgrade Singapore from an interpreter of the law to a leader in animal law. Singapore can achieve this through a targeted amendment to the definitions in Section 2 of the Animals and Birds Act. The proposed statutory formulation would legally redefine an animal as a vertebrate creature that is a sentient being capable of experiencing positive and negative states. This text is scientifically precise. It binds the law to biological reality by recognizing that animals experience a dual spectrum: positive states like pleasure and comfort, and negative states like pain and suffering. Upgrading the root definition of the entire act causes a cascading structural effect. This is known as a definitional amendment, a legislative technique where changing a single core definition automatically rewires every downstream clause and enforcement provision. Look at the impact on Section 41C, the duty of care provision. Owners would now be legally mandated to consider an animal's capacity for psychological suffering in their everyday care decisions. Under Section 42, which covers cruelty, psychological suffering is elevated from a debated judicial inference into an unassailable, independent statutory category of harm. This surgical definitional amendment is highly efficient compared to the years of work and political capital required to draft entirely new, standalone animal welfare legislation. Updating the definition bridges the gap between scientific truth and courtroom capability. When you codify sentience, that statutory text translates directly into enhanced law enforcement and prosecutorial power on the ground. This chart shows how an explicit framework enables structural upgrades. A clear definition creates the necessity for a specialized prosecution unit, equipped with the expertise required to prosecute complex psychological abuse cases. It also allows for the integration of standardized behavioral expert protocols. Veterinary ethologists would have a clear legal avenue to provide objective, reliable evidence of mental trauma in court. The ultimate institutional evolution stemming from this law change is the potential establishment of an independent animal welfare commissioner, an office that would oversee systemic welfare and conduct independent inquiries. Modernizing these laws impacts Singapore's international reputation and soft power. Explicitly recognizing sentience aligns with the nation's city and nature environmental vision and activates its role as a legislative leader within ASEAN. Formally recognizing canine sentience in 2026 fulfills Singapore's legal evolution. It replaces a property framework from 1965 with a scientific standard of justice that reflects the living reality of animals within its borders.